Good evening. I'm Ina Winston, and it's my pleasure to welcome you to Immigration Issues. As most of you know, this show is brought to you by the Chicago Legal Clinic, and I have with me our special guest, Ariel Valdez, who's a real estate attorney with our organization. For those of you who don't know about the Chicago Legal Clinic, we are a not-for-profit organization. We were established in 1982 by Ed Grossman, our former executive director, and then Father Paprocki, now Bishop Paprocki, who were two law school classmates at DePaul College of Law. Originally, the impetus for the establishment of the clinic was that the steelworkers had been laid off on the southeast side, and they needed high-quality, low-cost legal services, so we moved to fill the void. As a result, our flagship office is at 91st Street and About Exchange in Chicago. Since that time, we have expanded our operations, and we now have several satellite offices. We have an office downtown on Wacker Street, we have an office in Austin, and we have the office in which it's my privilege to work in Pilsen. We handle a variety of legal matters, from family law to immigration, general practice. We also staff part of the desk at the Daily Center, the help desk for people who need substantive representation and for people who want some pro se guidance. It's been my privilege to do immigration law at the Pilsen Legal Clinic, so our show is usually somewhat oriented towards immigration issues. Ariel Valdez is an experienced and well-regarded real estate attorney. He's been with the clinic since its early days, and he's bilingual. So those of you who speak Spanish should be very comfortable with Ariel. And I'm going to turn the show over to him now and ask him what the recent change in immigration climate has done for real estate. Because, of course, those of you who are immigrants know that deportations have increased dramatically during the first 3 months of this year. In fact, there's a 33% increase in the number of people who have been deported, many over the same time period last year. Now, many of those people do have criminal convictions, but about 5,500 of them don't. And more immigration agents are being hired, and we don't really know exactly what direction is going to be taken. Also, as you're probably aware, in previous administrations, there was a prioritization as to which immigrants were arrested, those being convicted of violent crimes being high on the list. And now there is no prioritization. Anyone who is undocumented can become a target. We don't know exactly how this is going to play out, but we do see in our offices a great deal of fear and concern, and legitimately so. And some of it focuses upon what to do about your children. So if we have time, I will talk about short-term guardianships concerning children. And Ariel will talk about the real estate aspects, because of course it's very concerning if you fear deportation as to what's going to happen to your property. So with that, I turn to Ariel. What would you like to tell us?
First, I guess a little bit of introduction of myself. I've been with the clinic, as you said, from the beginning, since about 1991. I've worked at the Pilsen office during most of that time. I started out at that time in 91. It was the end of the amnesty program, so we did a lot of immigration. Then transitioned and did a little bit more family law. Then eventually got into the real estate. So that's how I ended up now for the past probably 16 years doing almost exclusively real estate. So right now, as you said, there's a kind of a hysteria around the immigration. We're getting a lot of calls from clients wanting to know what to do with their property in case they get deported. So I've gotten several calls, people wanting to either try to transfer their property to somebody else in case they get deported, or as you said, the prepare a power of attorney. I usually wouldn't recommend an outright transfer to anybody for several reasons. One, obviously, when you transfer the property, if you transfer it outright, you're no longer the owner. If you transfer it, via quitclaim deed, and you remain on the title with somebody else, you're now a joint owner, and that can lead to a whole host of problems. One, for instance, is, let's say the other person is sued, there's a judgment, that could affect the property. So I strongly advise against doing that. I would recommend, if you're going to do anything, to prepare a power of attorney in the eventuality if you are deported, that you've named somebody that can manage your affairs. And a power of attorney you can use for more than just real estate. It can be for any property or any, managing your bank accounts or anything else, stocks, bonds, and anything else. So it's not just for your real estate, it's for any other personal property that you can use it for.
What are the kinds of actions that a power of attorney authorizes the person who's given the power to do?
Well, it really depends. You can limit it. You can limit it in scope to just certain aspects. For instance, with real estate, you can say, I just want it for, if you're selling it, I just want it for the sale of this transaction, or you can limit it however you want, or it can be broader in nature. So it really depends. It's on a case-by-case basis, and that's something that if somebody is interested in doing that they, you'd have to sit down, meet with the person, and see what they really want to accomplish, what they want to do with that power of attorney.
What happens once you've written the power of attorney? Who keeps it? Where is it? How does anybody know what's actually in it?
I recommend that they keep it in a safe place and let whoever their agent, who they've named as their agent, know, so that in case they become, because the power of attorney in most situations is if you're incapacitated or are unable to perform whatever you've set it up for. So if you're selling your house and you're going out of town, you're not going to be around, or you live out of state, you can prepare a power of attorney designating an agent to take care of the transaction. By the same token, if you can set it up that, hey, if I'm deported, I want to leave this person as my agent to take care of my real estate or whatever other property the person may have. But as far as who keeps it, that should be in a safe place. It doesn't necessarily have to be in a safe deposit box, which would probably be a bad idea, because that if you, for some reason, aren't around and the person can't get to the safe deposit box to have access to the power of attorney, then that's kind of worthless. So usually I'd say keep it in a safe place, and let the person that you've named as an agent where you've kept it. You've kept it in the drawer, in your desk or whatever, so that they know if they do need it where they can access it.
Are there any restrictions on who can be named as a person to whom you give the power?
Well, usually the person has to be, of sound mind, competent, and above the age of 18. To me, it should be somebody that you obviously trust, that you know. That would be my recommendation, that it's someone obviously that they do trust, that there's going to manage their affairs.
When the power of attorney is prepared, are there certain powers you can say you don't want someone to have? You don't want someone to be able to take out a second mortgage on your property, or you only want them to collect the rent and to remit it to you, and not to sell the property, but to just keep it up, keep the repairs up? Can you do that sort of thing?
You can do exactly as you mentioned. You can limit it to just very narrow in scope, so that if you want it for them to only be able to, if it's an apartment building, to manage it, to collect the rents, whatever, you can narrow it in scope, or you can make it broader in scope. And again, the statutory form has a list, and I didn't bring it with me, but of about from A to O of different transactions that you grant the power for. So, real estate, tax matters, Social Security, other bank transactions. So you can cross any of those out if you don't want the person to to deal with any other issue. So.
Do people ever have an obligation to have the power of attorney concerning real estate recorded with the recorder of deeds, or is there any court involvement, or is it just between the parties?
It's just between the parties. They do get recorded in a situation where the power of attorney is used to sell property or to purchase property. It will be recorded, and there is an extra requirement for the power of attorney if it's going to be used specifically for real estate transactions, and that is that it does also have to be witnessed. Normally, if it's going to be just for any other property transaction other than real estate, it would just need to be notarized. But when you're dealing with real estate, there's the additional requirement that it be witnessed and then notarized.
How many witnesses are required?
Technically only one in Illinois, but just to be on the safe side, because other states may require two, we usually just I do the two.
And who can be a witness?
Witness, the same as an agent has to be above the age of 18, and it's just a credible witness. Usually someone who is not going to be the beneficiary. So the agent couldn't act as a witness. It'd have to be somebody else.
Viewers, I'd like to remind you that you're more than welcome to call in with your questions. And I'm not entirely certain where the number is right now. But if you are a regular, here it is. It's 312-738-1060. So please feel free to call us up. Your question will be on the air, and it can help other people as well as yourself. So feel free. You're dealing with a real expert here. It's a chance to ask a question in any field of real estate, because Ariel is very experienced and very good.
Not any field. I don't do commercial real estate. Residential.
Let me bring up another topic, which is the issue of children and short-term guardianships. We're getting a lot of requests for short-term guardianships, so I thought I would tell you what the pros and the cons are and how a short-term guardianship works. A short-term guardianship is just an agreement among the parties to appoint a person to take care of the children for a limited period of time. It does not involve the court at all, and that's one of the positive aspects of it. Of course, the negative aspect is that it is short-term. It's for a year or less. It involves the appointing parent appoints an individual whom they trust to be the guardian of the named child. Now, I always suggest that if you're appointing someone whom you haven't grown up with, you go and you ask for them to get a police report. The nice person, God forbid, the nice person you're talking to, you don't really know and is a pedophile. You never want anything like that to happen. If you're living in the city of Chicago, that person can go to 35th in Michigan and get fingerprints and get a criminal history in Cook County. If they've lived outside Cook County, but in Illinois, they can file for the electronic fingerprint system and get a state of Illinois police report, which covers all the counties in the state. I also suggest that the guardian present 2 passport photos so that if the guardian is picking up a child from school, the school knows they're turning over the child to the right person. The form is very simple, very user-friendly. The appointing parent appoints, says that they are the parent of the named child, appoints the individual as a guardian, and the guardian should be an adult of sound mind, who does not have disqualifying crimes, obviously. It's best if the person who's the guardian is documented, because then you know that the person will not be deported, him or herself, but it's not statutorily required. You set the effective date. For example, some of these forms say that this appointment becomes effective on the following date, on the date that I am detained by federal or state law enforcement authority for more than 24 hours. Or you can set another effective date. The termination date is also set by the person who is doing the appointing. For example, it can terminate on the date that I am released from federal or state law enforcement custody within the United States, or on the date I give notice that it's terminated. And the notice doesn't have to be given in any particular specified form. The appointing parent signs the document, and it is witnessed by a person who's at least 18 years of age. We have 2 witnesses required under the statutory short-term guardianship. The short-term guardian must accept the guardianship and must also sign off. But the short-term guardian does not have to sign it at the same time as the appointment is made by the appointing parent. Now, this is very important. The other parent has to consent. The non-appointing parent must consent to the appointment of the guardian. This cannot be used to circumvent the rights of the other parent. If the other parent is not signing off, we have to prepare an affidavit explaining that it's impossible to get the consent of the other parent because the other parent, for example, is deceased, or the other parent cannot be found, and that requires actually making some effort, showing what efforts you've made to find that parent. Or the other parent has some kind of a disability that prevents them from caring for the day-to-day care of the children, and you have to explain what that is. Or for some other reason that's actually explained, and there has to be a sworn affidavit attached to this form. It's not a way for one parent to circumvent the rights of the other parent, even if the appointing parent doesn't like the other parent. It is a simple, basically 3-page form, and we'd be more than glad to help you do it. We have the forms both in English and in Spanish. We also have some information about preparing for an emergency in the event. I think it gives a person peace of mind. I hesitate in a way to keep on emphasizing preparation for deportation, because the reality is many people are put in deportation proceedings and many people have a defense. We've handled many deportation cases. There are sometimes simple defenses. The person may have a 245I case that is coming current. 245I, as those of you who are immigrants probably know, refers to a petition filed prior to April 30th of 2001. And that petition allows a person, upon the payment of a fine of $1,000, to adjust here in the United States rather than consular process, even though the person has entered without inspection and has worked without authorization. There are also circumstances where a person is not the direct beneficiary of the 245I petition, but is grandfathered in under a petition filed for another person, such as a spouse. Another possible way of fighting deportation is to have a U visa. U visas are a visa that, in general terms, is available to people who are the victims of certain qualifying crimes, most but not all of which are serious violent crimes. And the person calls law enforcement and helps law enforcement track down and apprehend this person and gets an affidavit to that effect. Of course, there is always cancellation of removal also for those people who have been here for a continuous period for 10 years and are of good moral character and can show that it would be an exceptional and extremely unusual hardship for their documented spouse, parent, or child if they were deported. But for so you should see an accountant if you're an attorney if you're fearing being deported. How to prepare for an emergency: you should have lists on hand of your doctors, your children's doctors, all the medicines which they take, the schools, the telephone number and address of your lawyer, and a list of your monthly expenses so that if someone does need to take over your affairs, they can step into your shoes and do so. You should have documents such as certified copies of birth certificates, marriage certificates, divorce decrees, all the medical records for you and for all your family members, a copy of your current passport and a copy of your consulate matricula, extra copies of keys to the house, a power of attorney for your finances, a power of attorney for health for those people who will be remaining in the United States. And if you own a home or other property, copies of the title to that property. And as we talked about, if you have children, a short-term guardianship is useful, and that later can be followed up by the short-term guardian going to court if necessary and getting a permanent guardianship for the children.
Can I ask you, just because I'm curious with the short-term guardian, is there a preference then if you were appointed short-term guardian to be the permanent guardian?
Well, there's a mention in the statute where it does explain that if the child's been living for a substantial period of time with the short-term guardian can come into court with a copy of that guardianship, explain the circumstances of the original appointment, the date of the appointment, why it's necessary to make it permanent. So the statute does give, it's not a decisive preference, but they do mention clearly that the short-term guardian is a logical person to come in if the parents are no longer available and to file for permanent guardianship of that child.
Okay.
Viewers, if you have questions, I remind you this is pretty much your last chance, last few minutes to ask questions from real estate expert. 312-738-1060. We do have copies of this document in both English and in Spanish, and we would be more than glad for you to come over to our offices in Pilsen. We're at 1914 South Ashland on the lower level, and we would be glad to talk to you about the emergency plan, about the short-term guardianship, about how permanent guardianship works, and explain the entire process to you. And of course, we have Ariel, who does real estate and travels to the various offices. And we have our other offices as well for other legal services.
I'll meet the client at whatever location is more convenient to them. So as you mentioned, we have the 4 offices, the one in South Chicago, the one in Austin, the downtown office, and obviously the Pilsen office. So I will, make arrangements and meet the client whatever's convenient for them.
So we would be glad to work with you. So please feel free to call our offices at 773-762. Wait.
No, the main office for an appointment would be 773-731-1762.
Sorry, here it is
Yeah.
for you. So please feel free to call, or if you have an immigration-related issue, you can just call us directly at Pilsen, 312-226-2669. And that wraps up our show for tonight. Thank you very much for listening, and come again on the 3rd Wednesday of next month. Thank you so much.
Thank you.